Thank you very much. Finally, we have Kirk Tousaw.
Thank you, Honorable Senators. I'm here as an individual. I'm here as a medical cannabis consumer myself. I use cannabis on a daily basis for chronic pain and have since I was 30 years of age. I'm also here, I'd like to think, as a voice for the hundreds of people I've represented in the criminal and civil courts over the years of working in this field, victims of prohibition that did not deserve to be criminalized for their conduct. With that said, a brief history lesson. 16 years ago, the late progressive conservative Senator Pierre-Claude Nolan chaired the Senate Special Committee on Illegal Drugs, which issued a comprehensive 600-page report on the issue that currently occupies this body's deliberations. How should the Government of Canada deal with the issue of cannabis? I had the privilege of speaking with Senator Nolan many times about this, and he regularly reminded me that he'd come to the issue a staunch opponent of legalization. As a father, he said to me, he was mainly concerned about the impact on his children. Senator Nolan, however, allowed and indeed demanded that the committee use a rigorous review of the evidence to drive its conclusions. And there was much evidence. This Senate study remains one of the most comprehensive analyses of cannabis and cannabis policy ever conducted anywhere in the world. The report began by acknowledging that at its most basic, the discussion is really not about people consuming cannabis. Under prohibition, Canadians consume plenty of cannabis. We grow it, we sell it, and we consume it in vast quantities. As the committee pointed out, the issue is really about whether criminalizing millions of Canadians for those personal choices is good public policy. The committee grounded its analysis in principles that should serve as guides to this body. Good public policy should promote freedom for individuals and society as a whole. The proper role of the state is based on respect for autonomy and individual and societal responsibility. Ultimately, Senator Nolan and the rest of the 9-member committee determined in 2002 that criminalization was bad public policy and concluded, quote, "The state of the knowledge supports the belief that for the vast majority of recreational users, cannabis use presents no harmful consequences for physical, psychological, or social well-being in either the short or long term." The committee also concluded that it was prohibition that actually caused the most harm to society. The main social costs of cannabis are a result of public policy choices, primarily its continued criminalization, while the consequences of its use represent a small fraction of the social costs attributable to the use of illegal drugs. Concluding that cannabis prohibition is harmful public policy, the committee recommended legalizing cannabis for Canadians over age 16 and granting amnesty to anyone previously convicted of simple possession. The committee's specific policy suggestion may seem familiar. Quote, "The committee recommends that the Government of Canada amend the Controlled Drugs and Substances Act to create a criminal exemption scheme. This legislation should stipulate conditions for obtaining licenses as well as for producing and selling cannabis, criminal penalties for illegal trafficking and export, and preservations of criminal penalties for all activities falling outside the scope of the exemption scheme." Honorable Senators, this appears to be precisely what Bill C45 proposes to do, and the Government of Canada should be commended for now moving forward with reforming our cannabis laws. That said, I disagreed then and I disagree now that a criminal law-based approach is appropriate. At most, cannabis should be treated in the same general way we treat alcohol, a much more dangerous substance. A regulatory approach with extremely limited offense provisions. And I dare say that the Senate committee believed that any vestige of a criminal law-based regime should be extremely limited, because one of the report's guiding principles is that, quote, "only offenses involving a significant direct danger to others should be matters of criminal law," end quote. In the intervening 16 years, we've learned much more about both the harms of prohibition and the impacts of legalization. We've seen experiments in legalization, both tacit and explicit, at home and abroad. We've had a system of legal access, including legal home production, of medical cannabis since 2001 in this country. We've had a system of commercial production and sale for medical purposes since 2014, which now has 300,000 participants. We've had a system of relatively open and widespread dispensary access in many major cities in Canada since 2014, and more limited dispensary access for more than 20 years. You can't walk 10 blocks in the city of Vancouver or downtown Toronto, or for that matter, Hamilton or Victoria or Seattle or Denver or Los Angeles without passing a storefront selling cannabis. These stores are selling, at least in Canada, so-called illicit cannabis openly and safely right now in almost every city and town in British Columbia and in most major population centers in every province in this country. This scares some people, and I understand that. Change is scary, particularly when you aren't familiar with the things that are changing. But I also understand that the evidence is clear that we have not seen and will not see the types of harms that so many seem to fear. Chaos does not reign in Vancouver. Every day you see people walking past dispensaries, and some going in the shop, just like they do every other store. 1 year after this change is implemented, I suspect we will mostly be wondering what all the fuss was about. I do have 4 specific recommendations. First, I want to reiterate my objection to a criminal law approach because such an approach will continue to have significant negative external consequences, such as the continued disparate enforcement against visible minorities and those with less economic means. I hope that we move beyond this approach swiftly. But at the very least, we must be expunging criminal records for simple possession so that our previous bad laws are not anchors weighing down our fellow citizens' life prospects. We should also remove all criminal penalties in C45 associated with simple personal possession and production of cannabis. On that point, secondly, I want to emphasize that lawful personal gardens are critical aspects of this reform. Allowing commercial production and sale, but criminalizing people, Canadians, with penalties of up to 14 years in prison who want to grow the exact same plant for themselves at home turns the point of legalization on its head. Legalization should and must be about not criminalizing individual Canadians for cannabis. The development of a vibrant industry will of necessity follow. Third, and as a parent of 4 children under 18, this comes from my heart. We must not criminalize young people in our pursuit of our laudable goals of trying our best to keep them safe and give them the tools they need to make responsible choices. We've tried the criminal approach. It isn't working now, and as the Senate committee determined, it is actually the single most significant source of harm from cannabis. A criminal penalty of up to 14 years in prison for a 19-year-old that shares a joint with her 17-year-old cousin is abhorrent and morally insupportable. Fourth, as we implement these changes, we must be looking for ways to transition the existing underground cannabis economy out of the shadows and into the light. This change is scary for them, too. Most, 95% of the domestic industry, are not involved with criminal gangs or violence in any way. I've represented hundreds of these folks over the years. They are small farmers, small shopkeepers, and people that love this plant. They are also a rich source of knowledge and experience, and let's be very blunt. If we don't bring them into the fold, many will likely to continue to operate outside of it. That is not good public policy. Finally, I want to thank the committee for the opportunity to address this critical issue. I also want to thank Canada for taking this step and bringing in legalization 1.0. It is not perfect, but it is an important first step. I look forward to your questions.
Thank you very much. And okay, thank you very much. Senator Dean.
Thank you. Mr. Tousaw, I'm picking up on your point about social sharing.
Yes.
And the impact of, in terms of closeness of age, an individual sharing with a peer or relative. What would be your advice if we were to try to tackle that? What would be a straightforward means of just opening the door a little bit to some limited social sharing?
Let's be clear, I think C45 takes some steps in the right direction by not criminalizing young Canadians for possession of under 5 grams of cannabis. But you're precisely right to say this close in age issue is a very serious issue. I mean, my daughter, my eldest daughter, is 17. Her peer group includes people down to 14 years of age and up to 18, 19, 20 years of age. And it is perfectly normal behavior for young Canadians that are 19 to potentially use cannabis and share cannabis with their peers that might be under the legal age, under C45. We have a close-in age exemption to sexual conduct laws, for example, in the criminal code. And that type of close-in age provision, if you're within 2 or 3 years of the person you're engaged in the activity with, could easily be imported into this. But I think that doesn't necessarily go far enough, because one of the things this bill also does is it criminalizes a parent who would want to have their teenager, for example, use cannabis in the home as opposed to out with their friends or out at a party or something like that. I mean, with alcohol right now, you can allow your children to use alcohol in your home without fear of criminal penalty. And that makes sense. That's how you teach young people appropriate behavior. This sort of forbidden fruit idea actually drives people towards unsafe use of substances. We see it with alcohol, we see it with other substances. And so I think it's important to recognize that, you know, parents need to have an active and participatory role in their young person's development, in their children's development. I would much rather that my children are introduced to cannabis on my back deck by me than by a shopkeeper or by a peer driving around or at a party with other 16, 17, 18-year-olds. And we know they're doing it. Look, let's not pretend here. We have some of the highest youth rates of cannabis use in the Western world. That's not... And our kids are pretty good. You know, they're doing pretty well. We have really good outcomes in this country for a lot of children. It's obviously socioeconomic dependent, as all things are. But we need to be sensitive to these kinds of issues, and we need to not be looking at people and saying, well, you could go to prison for 14 years if you pass a joint to someone in your peer group. That seems to me to be completely wrong-headed.
Thank you. Do I have time for one quick question?
Yes.
For Ms. Black?
Mr. Poirier.
Thank you, Chair. Thank you all for the presentation. Greatly appreciated. My first question is for Mr. Tousaw, if I'm saying that right. Okay. We heard a lot in committee talk a lot about the education on the risk associated with cannabis, but not so much on, not nearly enough education on the consequence of the law.
Mm-hmm.
And when it comes to possession or home growth or age limit, in your opinion, are Canadians young and old well-informed, aware enough today of the consequences of C45? And if they're not fully aware of the consequences of C45, what could be the impact, in your opinion, on the juridical system?
I think that's a very insightful question, and I'd even broaden it further. Not only are Canadians not well aware of the impact of C45, Canadians aren't very well aware of the current laws surrounding cannabis. I cannot tell you how many people I talk to that think cannabis is legal right now. It's absolutely stunning. I talk to people that are in the regulated industry that don't know how the rule set works. The lack of knowledge, and look, it's complicated, right? I mean, you read legislation, you folks have all done it. It's not easy to do. You have to slog through it. It's referential. You have to think about it in a deep way. But there's a tremendous amount of confusion out there. And the problem with that is the legislation has so many sort of arbitrary limits that the people are going to just of necessity run afoul of it. For example, you're going to be allowed to possess 30 grams of cannabis, dried cannabis, and then there's this equivalency ratio that then applies to other cannabis products. So you're going to sort of have to do this math in your head when you leave your house. Well, I can bring 2 cookies with me, but not 4, because 4 means I'm breaking the law and 2 doesn't. Or I have this jar of cannabis here, and what? So I have to weigh it before I leave the house? It doesn't make a lot of sense, and it's completely arbitrary. When you go to the alcohol store, I mean, you can go into the alcohol store and buy enough alcohol to kill a small town and put it in the trunk of your car and drive away. Mm-hmm. And what we depend upon is Canadians exercising individual responsibility. We don't depend on the government to say, well, you can only buy 6 beer at a time each day, or you can buy 6 beer now, and then you can go home and drop it off. You come back to the store and you can buy another 6 beer and go home and drop it off. But that's the system that we're going to have for cannabis, and it doesn't make a lot of sense. And that's why one of my recommendations to this committee is that all criminal penalties associated with personal, not commercial, with personal possession and production of cannabis should be eliminated from C45. Canadians deserve to stop being criminalized for their personal, individual choices. They deserve that from this committee and this government. That's the point of legalization. There also has to be education. Obviously, the government, I think Health Canada is doing a very good job so far of educating people at each step along the way what the changes look like and what the ramifications might be. But the best thing we can do for Canadians is just make it simple. You're allowed to possess cannabis. You're not allowed to unlawfully sell it. You're allowed to possess it. You're allowed to grow cannabis. You're not allowed to grow it, just like you can't make beer and sell it out your garage. You're not allowed to grow it and sell it out your garage. But you shouldn't risk going to jail for 14 years because you have 5 cannabis plants in your garden instead of 4. That just doesn't make much sense at all.
Thank you. More.
Senator Manning.
Thank you, Mr. Chair, and thank you for our witnesses. Just quickly, Mr. Tousaw, following up on your comment in regards to the, I guess, confusion that's out there. I believe there's as many people confused as thinking that we're talking about decriminalisation here instead of legalisation with people that I talk to. And whether we're talking medical use. I'm just wondering, the C.D. Howe Institute has recommended that the government consider pardoning people previously convicted for cannabis possession and dropping any outstanding charges to free up much-needed resources for cannabis legalisation. The government has said that they don't intend to pursue pardons at this time. I understand you've previously expressed your disappointment with this decision. Is there any reason why the government couldn't go ahead with some form of amnesty with legalisation?
Great question, Senator. No reason whatsoever. There are literally thousands of pending simple possession cases in the criminal courts of this country sitting here today. People have been arrested to the tune of about 25,000 for simple possession per year while the government of Canada is debating this legalization process and bringing it in. That is unjust. The Justice Minister can direct the Public Prosecution Service of Canada to discontinue all prosecutions for simple possession or any cannabis offences at any time that the minister chose to do so, and I urge the minister to do that. We just had a Supreme Court of Canada decision in Jordan about excessive delay. We see an already overburdened court system creaking its way day by day into further decline. We don't have enough judges. Why are we spending scarce resources prosecuting people for simple possession of cannabis? We also know, by the way, that simple possession is enforced in a discriminatory manner against visible minorities and persons of lower socioeconomic status. This is an absolute unethical, immoral process. We should stop. We should have stopped a long time ago prosecuting simple possession. Senator Nolan's report came out in 2002. So I think it's an important step, but there's so much more we can do. And we can do it without legislative change. We can do it by policy.
Just yesterday, I believe there's people charged in my home province of Newfoundland and Labrador with possession, and here we are debating this issue here.
Well, that's right.
But just as a quick follow-up, the government has spoken at length about how the Cannabis Act will crack down on organised crime. We've heard conflicting evidence on whether or not this will actually be effective. We've heard from many sides, many different stories. One of the ones that they keep using here over the past is what's happened in Colorado. Last night on the CBC National News, Briar Stewart did a report on what's happening in Colorado and the fact that the organised crime black market seems to be just gone out through the roof. There's so much of it down there. So I'm just wondering, maybe you could tell us, help us understand the different perspectives on the presence of organised crime in the illicit market. Who's currently supplying Canadians with illegal cannabis? Is this criminal gang activity on a large scale, as the government suggests? That's something that we need to be looking at here.
A huge misapprehension is that people involved in the illicit cannabis economy domestically in this country are connected to organized crime. The referenced earlier in the earlier panel, and I referenced in my comments, about 95% of the domestic cannabis industry is not what we normally think of as organized crime, criminal gangs, people that are engaged in the use of violence. Most people, and I've represented hundreds, if not over 1,000 people charged with cannabis offenses over the last 15 years. I can tell you that with very, very few exceptions, I would invite them home to my, and have invited many home to meet my family and sit at my kitchen table. They're good people. They're people that are otherwise law-abiding. I think using terms like crackdown is part of the problem. C45 is not going to crack down on organized crime. The only way, and I think the entire experience of Prohibition is evidence of this, the only way that you eliminate an underground economy in a product is that you make it lawful and that you make it easy for people to transition out of the very vibrant, very well-entrenched illegal economy that exists today, out of the shadows and into the light. And Health Canada, I think, has taken several steps in the right direction with the promulgation of microproducer rules, microprocessing rules, and its policy decision not to automatically bar people with prior involvement from participating in the illicit industry. The individual provinces have taken varying approaches to that. British Columbia, I think, has said very explicitly, we're not having an automatic bar. On the other hand, Alberta's gone in the other direction. And so Alberta, with an otherwise, I think, very robust private retail system, has said, look, if you have any experience selling cannabis, you can't participate. Well, that seems to me to be a miss. Prohibition, criminal law penalties, including mandatory minimum penalties brought in 2012 by the former government of this country, have not made any impact in supply, consumption, or demand for cannabis in this country. Right? They don't reduce it. And so we can't criminal law our way out of this issue. We have to use common sense economic strategies. The illicit economy will go away when the licit economy is easy to participate in, carries the same range of products that the illicit economy does, and sells them with good customer service at good or better prices. That's how you get rid of the illicit economy. The idea that we're going to do it with a criminal law approach, I think, has proven to be a spectacular failure.
Okay, I have to move on, sorry. Second round, sure. Senator McCallum.
Thank you for your presentations. Tousaw? I was wanting to talk a bit more about the criminalization of the youth.
Yes.
And I agree with you with that. Because marijuana is used by a lot of young people to I'm from a reserve. It's to deal with the social issues that they have. And I don't know if you've read Gordon Cruz. He worked with a lot of juveniles that were in detention systems. And that he said, and he interviewed former residents. And they said to him, don't criminalize the young. And to give them alternate programs. Can you speak a bit about that?
Well, I think that's very sensible. Let's just situate this. The use of cannabis by young people is part of growing up. It's normal,
it is.
Standard behavior. Not for everyone, but for a substantial portion of our young people. They are going to use cannabis. They are going to use alcohol when underage. They're going to do these things. We can't stop that. So what can we do? Well, we cannot make the impacts of that use dramatically worse by also involving them with the criminal justice system. Involvement with the criminal justice system for simple possession of cannabis provides no benefit to the young person. In fact, it's all negative. You become fearful of police and resentful of police. You become entangled with the criminal justice system. You might have a lifelong criminal record. You might not be able to cross the border in the United States. Future employers might turn you down. There's a host of negative consequences that arise simply because we've chosen to label that normal behavior as criminal behavior. We need to take a different approach. Our young people are the most precious resources we have. I have 4 children between the ages of 7 and 17. You know what? I don't worry about the fact that they may try cannabis. What I worry about is the fact that they may try cannabis and then become arrested by a police officer and develop a lifelong aversion to going to the police when they're in need of them. And I was this 16-year-old. You know, I was arrested for simple possession of cannabis more than once. I developed a real antipathy to police officers. And it wasn't until I became a practicing lawyer and worked with them on a daily basis, in an adversarial capacity, granted, but on a daily basis, that initial sort of feeling went away. And I realized that these are, human beings like everyone else, trying to do a very difficult job. And in the area of substance use, they've been tasked with an impossible job. It's impossible. They should not be the frontline response to substance abuse. Parents, educators, and social workers should be the first line of response, not the criminal justice system.
Okay.
In the modern cannabis world, we do have access to laboratories. So if I'm dealing with somebody who's brand new to using cannabis, I will tell them if they need THC, if they're looking for, say, pain control, that they take equal amounts THC and CBD to balance them together, and you start at 2.5 milligrams, which is a very small amount. And then I encourage people to wait 24 hours before they increase by 2.5 milligrams. And this system can pretty much guarantee that it's going to avoid adverse effects. And it's the same kind of knowledge that we can easily translate to the recreational market when it comes to using potent products, about how to use them in a very safe way where you start slow and you go very slow, but in a precise, measured way. And people will learn what the amount is that they need for the desired effect while avoiding any of the adverse effects.
Okay, thank you.
One quick sentence.
Very quick.
That's not really any different from how we deal with other medicines, right? I mean, your doctor will prescribe you a painkiller and say, take one, and if it works, don't take two. And if it doesn't work, maybe the next day, try taking two, up to a maximum.
Okay.
We're familiar with this.
Thank you. That completes round one. I have a question for Mr. Tousaw before I go to round two. What you're saying about removing criminal penalties for simple possession, I totally agree with that, particularly as it relates to our young people. But you and others have pointed out this whole question of social sharing, 19-year-old with a 17-year-old, and all those combinations, or they, you can end up in the youth criminal court with more than 5 grams, and yet an adult can have 30 grams. We've got all those things about close in age, social sharing, etc. Now, one point of view is, and I know a lawyer would never consider this acceptable, but one point of view is that they would never actually be prosecuted. That those kind of prosecutions would not take place, even though technically they are a violation of the law. Technically, if you, in some cases it could be a fine, but it could eventually lead either in the youth criminal court system or the adult criminal court system. It could lead to something more than that. So what do you say to that, oh, well, there's nothing to worry about here?
Well, I have a two-part answer to that. The first part is that it's a common misconception that simple possession cases are currently not prosecuted in this country, and yet 26,000 people a year end up prosecuted for these offenses.
A lot of them minorities.
Well, and that's the second part of my question.
Yeah.
Is my child, white, privileged, with a lawyer for a father, going to get prosecuted? No. But you know what? That's not good enough, because we know that these laws are applied in disproportionate manners against marginalized people, against visible minorities, against people of different socioeconomic status. And so I don't think it's acceptable that some people, like my children, like Mr. Trudeau's brother, get to escape criminal prosecution because of what they look like or their connections, and while others who don't have those connections, who don't look that way, end up in the criminal justice system. That's what we see today. That's what we're going to see in the future. Disparate enforcement of these laws, and it is absolutely unacceptable in a free and democratic society.
Okay.
Mr. Chair, once again, thank our witnesses. I'm a big supporter of decriminalisation, not necessarily of legalisation. I wanted to follow up with questions I was asking you before, Mr. Tousaw, in regards to the possibility of different provinces having some different rules. As I watch in Colorado as an example of some of the concerns that are in that area, is the fact that Colorado has legalization while the next state may not. Quebec, from what we hear, is not going to allow homegrown, where New Brunswick is. You mentioned about British Columbia versus the storefronts in Alberta.
Yes.
I'm just wondering from a legal point of view what your concerns would be in relation to the fact that we're going to have a national law, C45, but we're going to have provinces that are going to have different jurisdictions that we do, but are we going to have concerns from province to province interrelated?
I think we are, and I always like to divide this issue into two different things, commercial versus consumer, right? The business plan, the commercial regulation, I have concerns about, But the Como case in the Supreme Court of Canada made clear that provinces are entitled to regulate differently than each other, and even to impose certain barriers on interprovincial trade. And I don't think we're going to see another challenge to that provision for a good long time. My difficulty is on the consumer side, on the individual side. Look, on the commercial side, I think I have preferences. I think private retail is better than public monopolies. I think it makes a lot more sense. I think we're going to end up there eventually. We're going there for alcohol. It just makes more sense. But on the individual side, it's absolutely inappropriate to legalize personal production of cannabis across this country. And the federal government in this country is the sole source of criminal law jurisdictionally. But Quebec's to step in and say, well, this behavior that's otherwise lawful in the rest of the country, we're going to punish you for. We're going to criminalize this conduct as a province. Not only is it wrong-headed, because it's going to lead to the continuation of the problems that prohibition causes, but I just think it's not fair. Why should someone, 1 foot across a line, be able to grow 4 plants perfectly legally, and the person on the other side of that line, and maybe even be neighbors, can't do that, and the police could come in and arrest them for it? That is absolutely inappropriate. It should not be tolerated, and quite frankly, I think ultimately the courts are going to resolve that portion of the issue. I don't think it's constitutional for a province to criminalize otherwise lawful behavior that's lawful across the rest of the country. And if I spoke French better, maybe I'd take a case like that, but unfortunately I don't.
Yeah. No, thank you. That's fine.
All
right. No, thank you. That's fine.
All right. Okay. Senator McCallum, you have another question.
I wanted to ask you if you feel that the excise tax and the criminalization of youth, would you say that's discriminatory?
Well, I think it is, particularly the excise tax. I join with everyone you've heard today to say applying an excise tax to medical cannabis. And let's be clear, it's not currently applied to medical cannabis. So we are adding a tax to sick and suffering citizens' burdens. So we should not be doing that. But any of these policies, just because of the way our society is structured and the institutionalized racism that we have, and the institutionalized socioeconomic discrimination that we have. Any of these issues are magnified when applied to people of marginalized groups, visible minorities, and people of lower socioeconomic status. Taxes hurt those folks more than they hurt people with means. I can pay the extra $1 a gram, even for my medical cannabis. I can afford it. But a lot of people can't. And we should be concerned more about those people than about people like me that aren't going to have these kinds of difficulties. And the same is absolutely true of every other aspect of taking a criminal law approach to this issue.
Okay, well, the Senate is meeting in another 15 minutes, so time to wrap up. So I want to thank the 3 panelists that we've had in the second panel. You've been most helpful to us, and appreciate the answers you've given to our questions. And colleagues, before you leave, I would remind you that we are back again tomorrow morning at 8 a.m. We have 8 a.m. We have 4 hours of dialogue with various officials on the 4 reports that came from the other committees. I also want to remind you that any amendments or observations to the bill, because on Monday at 3 o'clock, I think it is, we start at 1 o'clock on Monday, but we have an hour and a half with Mr. Blair and officials from Health Canada. But then at 3 o'clock, after a half-hour break between that session and clause by clause, we go into clause by clause. So amendments and observations, remember the request is they must be in both languages, and to fit the format of the clause provisions of C45, they must meet that provision. You can't just have a general wording. It's got to meet the provision that goes into the bill, and that's why we suggested you consult the law clerk with respect to that. Those are due by 4 p.m. Tomorrow, so that we can get them all sorted out and get them ready for Monday. And we'll be getting them on the weekend, so there won't be much of a weekend break, but we'll be ready to go on Monday. So please